Welcome to the Interstate Compact on the Placement of Children, Submitting an ICPC Referral webinar. This is the training for when Wisconsin is the sending state and your agency wishes to place a child in another state. This training will give you an overview of the steps for considering an out-of-state placement, assembling and submitting the referral, what happens when the referral is sent to another state, and information for after the child is placed in the other state. This training will not walk through the EWIS-ACWIS process for submitting a referral. For information on that, please visit the DCF Knowledge Web. To review the ICPC basics, the Interstate Compact on the Placement of Children, referred to as ICPC, is a legally binding contract between states that regulates the placement of children across state lines in order to protect the best interests of the child. It's made up of 10 articles and 12 regulations that set the requirements for ICPC, and it applies in most situations when a child is involved with the court or under the jurisdiction of an agency. For more information about the basics of ICPC, view the Understanding the ICPC webinar, which will provide more information. First, let's briefly review the ICPC workflow when Wisconsin is the sending agency. It begins when there is a Wisconsin sending agency that would like to make placement of a child out of state. This is the county or the public adoption agency that will maintain planning and financial responsibility for the child. That agency submits the ICPC referral to the Wisconsin State ICPC office. Wisconsin is the sending state, and the office will send the referral to the receiving state ICPC office. The receiving state ICPC office will then assign a local agency in the receiving state to complete the home study on the proposed placement resource. This local agency will then complete the home study and send the results to the receiving state ICPC office, which will send to Wisconsin, and the Wisconsin ICPC office will communicate the results of that study with the sending agency in Wisconsin. So we've reviewed the overall process, and let's begin to go through each step of the process when Wisconsin is the sending state. First, an out-of-state placement resource must be explored and considered. Before you even pursue an ICPC request, you must discuss the potential placement with the proposed resource and gather as much information as possible. Here are a few things that you should discuss or consider. First, is the proposed resource even willing to accept placement of the child? Second, is the proposed resource willing to cooperate with the ICPC and the agencies involved in the child's case? You should note that each state has different requirements for studying a proposed resource. For example, some states require that all placement resources have to be licensed. You should get an understanding from the resource what requirements they are willing and able to meet in order to later avoid delays or confusion. Third, you should ask what kind of history does the proposed resource have and what is their relationship with the child. Of course, is moving to another state the best interest of the child? Also, what supports will the placement resource need once the child is placed, and can you access those resources? And after considering at a minimum those factors, you should review whether that home is even still appropriate for placement. If it is, and you still want to pursue out-of-state placement, step 2 is to determine the regulation type. Now, while the process of creating an ICPC referral in EWIS-ACWIS will help you determine the regulation type, it's important for you to have a basic understanding of the difference between the regulations. Each regulation has different requirements for the referral. First is a Regulation 1, relocation of the family unit. This means that the child is currently placed with an approved resource in Wisconsin, and the child is moving to another state with the approved resource. In the other state, supervision of the child and the child's placement will continue. Second is Regulation 2, public court jurisdiction cases. These are our most common. It may be for a parent, a relative, a foster parent, or a pre-adoptive placement. It could also be a conversion request from one of these to the other, and the request may be for a licensed or an unlicensed placement. Regulation 4 is residential placements into group homes or residential care centers out of state. It requires acceptance from the facility prior to the request and also requires a hearing if the child is an adjudicated delinquent. Our Regulation 7 expedited placement decision, they only apply in very certain circumstances. It requires a specific court order prior to making the referral. Okay, so now you have a general understanding that there's different types of regulations. You're ready to start submitting the ICPC referral. This referral is your request for your home study and is submitted through eWisAquis to the Wisconsin ICPC office. While this training doesn't walk you through that specific eWisAquis process, there are many resources available by visiting the DCF Knowledge Web. In videos and user guides, there are walkthroughs to help you through the process. The ICPC referral was designed to walk you through the ICPC process by filling out different tabs with information about the child and the placement resource. The second tab will help you determine which regulation type applies and then ask you for information based on that type of regulation. You will also provide information about the child and about the proposed resource. And finally, you will upload the necessary documents for ICPC specialists to review and forward to the receiving state. The information and documents required for an ICPC referral will vary based on the regulation type, but there are several forms that are required for most regulation types. The 100A. This form is generated in eWisAquis and is required for each placement request. It provides basic information about the request, such as the type of care you're requesting, whether the placement is for the purposes of adoption, the legal status of the child, and what services may be requested. This form is also used as the approval or the denial from the receiving state. Second is the worker statement. This form is also generated in eWisAquis and is required for most types of ICPC requests. It's crucial to ensure that the sending state has communicated with the proposed resource about their home and the plan for placement. This information on the form is required to be gathered prior to making the placement request, and the sending agency caseworker can only make the request if the proposed resource is willing and able to accept placement, and the agency views it as an appropriate option for the child. Third, the financial medical plan. This is also generated in eWisAquis and provides the receiving state with information about the financial plan to support the child, as well as how medical care for the child will be funded. Regardless of what plan is chosen, the sending agency remains ultimately financially responsible for the child and will retain jurisdiction over that child during placement in the receiving state. The sending agency is responsible for determining what assistance the proposed resource is eligible for, including kinship and foster care payments. If Wisconsin is paying kinship care to an out-of-state resource, the resource is required to go through the licensing process in the receiving state per our levels of care requirements. The Wisconsin agency should submit a conversion request to the Wisconsin ICPC office as soon as it's possible in order to pursue licensure in foster board payments for the resource in the receiving state. Finally, we have the cover letter. The cover letter is an opportunity for the sending agency to summarize their request and emphasize any specific information or concerns relevant to the request and the placement resource. The cover letter should identify the child to be placed, as well as contact information for the proposed resource. It should also provide a brief statement about the legal status of the child, the reason for the proposed placement, and the long-term plan for the child. Any special circumstances or considerations for placement should also be specified if it's not included in other documents. There is no template for the cover letter. There are additional documentation requirements for each regulation type, so let's review each type in more depth. First, Regulation 1. This regulation applies when the child is currently placed with a licensed or approved resource in Wisconsin, and that resource would like to move to the receiving state, and supervision of the child's placement will continue in the receiving state. This regulation applies in several types of situations. If the child is currently living with a parent and the agency plans to maintain jurisdiction in the new state, an existing relative or kinship care placement, or with licensed foster parents or pre-adoptive parents. Note that if the child moves with the approved resource to the receiving state as a temporary relocation for less than 90 days, an ICPC request and approval of the receiving state is not required. During this temporary relocation, though, the sending agency is responsible for the monthly supervision of the child, and the receiving state is not required to provide supervision without going through ICPC and getting approval. If the sending agency wants to request supervision from the receiving state, there must be an agreement in place and the ICPC offices have to be notified. If the temporary relocation is recurring, the sending state should submit an ICPC request and the receiving state has to give approval of the proposed resource. When a family is relocating to another state with the child, the sending agency must submit the request for a Regulation 1 to the sending state's ICPC office within 3 business days of the move. In addition to the 100A, worker statement, financial medical plan, cover letter, and a 100B disclosing placement, the agency will need to submit the following documents in the ICPC referral: a court order placing the child or a statement that supervision is ongoing, a case history to include placement and social history, court involvement, social dynamics, special needs of the child, and other relevant information to the placement. This information doesn't need to be on a separate document, but can be included in other documents such as the case plan, permanency plan, court orders, etc. Additionally, any licensure, certification, or approvals from Wisconsin, including any verification of completed training, any existing home study or updates to that home study, progress reports for the last 6 months, and the most recent judicial, court order, or court report, a case plan or a permanency plan, birth certificate and social security card if available, and the petition or the order for the TPR if the request is for the purposes of adoption. Please be aware that the receiving state may require additional documentation or information from you. For example, many states are now requiring that proof of paternity is sent if the proposed resource is a paternal relative or the father. If the state requires more information, the ICPC specialist will notify you of what additional documentation is required. Okay, let's review Regulation 2 requests. This is the most common regulation type. For Regulation 2 requests, the child is under court jurisdiction for abuse, neglect, or dependency as a result of action by the Child Welfare Agency. It applies when the child is not yet placed and when placements are already approved by the ICPC and there's a change in status. For example, an unlicensed relative or kinship care home is becoming a licensed foster home, or a licensed foster home is now an adoptive placement and an adoption home study is needed. In these cases, a new ICPC referral is required. This is because often information must be updated, and in certain circumstances, such as needing an adoption home study, it's required that a new agency in the receiving state be assigned. In addition to the 100A, worker statement, financial medical plan, and cover letter, the agency will need to submit the following documents in the ICPC referral: the court order placing the child or a statement that supervision is ongoing, case history to include placement and social history, court involvement, social dynamics, and special needs of the child. This information, again, does not need to be in a separate document, but can be included in other documents such as the case plan, perm plan, or court orders. Information about the child's placement history in the sending state in Wisconsin. Information about the placement resource, if that resource had children placed with them here in Wisconsin. the case or the perm plan, a birth certificate and social security card if available, and the petition or order for TPR, again, if the request is for the purposes of adoption. Just like with Regulation 1s, please be aware that the receiving state may require additional documentation or information. Next, we have our Regulation 4 requests. These are placements in out-of-state facilities. The ICPC does not include institutions primarily educational in nature, hospitals, or other medical facilities. These types of facilities are defined by the receiving state and is determined by the services that the facility provides, not the type of license or source of funding. For additional information or help with determining how a facility is defined, you can visit ICPC regulations online. This regulation applies whether the child is under jurisdiction of a court for delinquency, abuse, neglect, or dependency. Please note, if the child is an adjudicated delinquent, there has to be a court hearing, and the court must find that equivalent facilities for the child are not available in Wisconsin, and that institutional care in the other state is in the best interest of the child and won't produce undue hardship. When you're submitting a Regulation 4 request, the following documents are needed: a 100A, a letter of acceptance from the facility, which allows the ICPC office to verify that the facility is willing to accept the child and has been determined to be appropriate to the facility, a court order or other proper authority to place the child, and again, if they're an adjudicated delinquent, the order has specific requirements, the financial medical plan. I want to point out here that agencies should note that there will not be a child welfare agency involved in the receiving state that can set up Medicaid for the child in that state. If the facility is not willing to set up Medicaid for the child in the other state, your agency is responsible for paying for medical coverage. You will also need a placement disruption agreement, which sets out responsibilities of each agency in the event that placement disruption occurs. This will include the costs and the transportation, and this agreement must be signed by both the sending agency and the facility. Be aware there is no template or form for this agreement, and your agency needs to create it. And finally, if applicable, the case or the permanency plan for the child. Regulation 7, expedited placement requests. These are the most commonly misunderstood regulation, as they only apply in certain circumstances. In order to be an expedited placement request, the request must meet all of the following. First, the child is involved in child welfare. Second, the proposed resource must be a qualifying relative or guardian. Please note that the definition of a relative under Chapter 48 does not apply under this regulation, and the proposed resource must be one of the following: a parent, a step-parent, a grandparent, an uncle, an aunt, a brother, sister, or is the child's guardian. Please note this does not include great aunts, uncles, or great grandparents, etc. In addition to those two requirements, one of the following circumstances must be met. The child has an unexpected dependency due to incarceration, incapacitation, or death of a parent or guardian. Incapacitation means that the parent or the guardian is unable to care for a child due to medical, mental, or physical conditions of that parent or guardian. Second, the child is 4 years of age or younger, or the child has siblings 4 years of age or younger that would be placed with the same resource. If the court finds that the child or any child in the sibling group has a substantial relationship with the proposed resource, which means that the proposed placement has a familial or a mentoring role with the child and has spent more than just cursory time with the child and more than a child is currently in an emergency placement. Please be aware that this regulation will not apply if the child has already been placed in the receiving state in violation of the ICPC, if the intention of Wisconsin is that in the receiving state, the resource will immediately be licensed or approved for foster care or adoption. It will also not apply if the resource is a parent and the court has no evidence that the parent is unfit, does not seek any evidence from the receiving state that the parent is fit, and the sending state will immediately close jurisdiction. If you remember from the Understanding ICPC webinar, these placements are not subject to the ICPC. So if your placement fits the definition of a Regulation 7 expedited placement request, before submitting the request, your agency must speak with the proposed resource and verify they meet the definition of a Regulation 7 and are willing and able to care for the child and cooperate with the ICPC process. And then you submit that verification to the court with a statement that you're ready to make the ICPC referral to the Wisconsin ICPC office. By doing this, you obtain a Regulation 7 court order of compliance. This must be on the Order for Expedited Placement Decision, our Priority Placement Order form, which is JC 1648. This must include whether there's a request for provisional approval from the receiving state, and then this order must be sent to your agency within 2 business days. Within 3 business days of receiving that court order, your agency must submit the following: a 100A worker statement, financial medical plan, and cover letter, a priority home study request form, which is obtained in EWIS-ACWIS, the priority placement order we just discussed, case history of the placement and social history, court involvement, special needs of the child, and other relevant information, which again can be included in other documents and does not have to be a new document. Any information about the child's placement history in Wisconsin, any information about the placement resource if the resource had children placed with them here, the case or the permanency plan, and the birth certificate and social security card if they're available. Just like the other regulations, I want to remind you that the receiving state may request additional documentation, especially with Regulation 7 requests. They usually ask for proof of paternity if the proposed resource is the parent, the father, or a paternal relative of the child. Now that we have reviewed the 4 different types of regulations you may be submitting, there are some other considerations that you may want to take when you are preparing to submit an ICPC referral. First is whether you are requesting multiple resources have home studies in the receiving state. While this is allowed, you should note that submitting referrals for multiple home studies on multiple resources can put a significant burden on the receiving state to complete those home studies. If you are requesting multiple resources when you know that you want to place with one specific resource, you should consider sending separate ICPC requests at different times based on the priority of placing with certain resources. Again, this is not required, but is a consideration to make based on the child's situation. Second, your intention to place. You should not request a home study on a resource if there's no possibility or intention to place the child with that resource. If your court has ordered an ICPC request should be submitted for a resource your agency wouldn't have otherwise considered, you should include information about those concerns and the reason for the request in the cover letter submitted with the ICPC referral. Finally, consider that other states may not accept requests for multiple home study types at one time. For example, the receiving state may not allow you to request that a home be licensed as a foster home and studied for adoption at the same time. Some states actually require that you have a foster home study approved, have placement occur, and then study the resource for the purposes of adoption with a new ICPC referral. This is not with every state, but is a consideration that you should be aware of. Okay, so after you have submitted your referral, the fourth step is that the Wisconsin ICPC specialist will review the referral and take action. They will first review the referral for completeness and for compliance with all applicable laws and regulations of Wisconsin, of the ICPC, and of any known requirements of the receiving state. And after they review the referral, they will do one of the following. First, they could deny. And though it's uncommon in certain circumstances, the referral may be denied and will not be sent to the receiving state. Or the ICPC specialist may return the referral to the sending agency. They may do this to obtain corrected information or obtain additional information that may be missing from the referral. If the referral is returned to you, you will be notified, and it will be your responsibility to get the requested information to the ICPC specialist as soon as possible to continue timely processing. Lastly, they may accept the referral and send the referral to the other state to be processed. Step 5, once the ICPC specialist has accepted the referral and sent it to the receiving state, the receiving state ICPC office will also review and ensure that all necessary information is provided. And if more information is needed, the receiving state ICPC office will communicate with the Wisconsin ICPC office to connect with you for additional information. And then once their review is complete and they have accepted it, they will assign it to a local agency to complete the home study. So once assigned, the local agency will complete the home study on the proposed resource. The local agency in the receiving state will follow all local and state regulations to complete that home study. Again, some states have specific requirements on the type of home study that can be completed. For example, Minnesota currently requires that all proposed resources go through the licensing process regardless of the type of request from the sending state. Wisconsin is unable to require other states to follow different home study or licensing requirements. The local agency may make a home study report to update the sending state on the process of the home study, but in this report, they are not required to make a placement decision. I should mention that the home study report is not a complete home study or licensure, but it's an update on how the home study process is going. Some states will send a home study report and then will need more time to complete the approval or licensure. If placement is made after this report without an official approval from the receiving state, and then the request is subsequently denied, the child must return to Wisconsin. And once the home study is complete, the local agency will make a placement recommendation to the receiving state ICPC office based on their home study. So after that recommendation is made, the receiving state ICPC office will review the local agency's home study and again ensure that all applicable laws and regulations are met and that the placement is not contrary to the best interests of the child. And then once that review is complete, they will approve or deny the placement and send the decision on assigned 100A to the Wisconsin ICPC office. If the placement is denied, placement cannot be made. And if the child was already placed in the receiving state, either on a provisional approval or illegally, and the placement is denied, the child must be returned to Wisconsin. the Wisconsin ICPC office will notify the sending agency of the receiving state's decision. So there are a few different timeframes that you should be aware of when thinking about an ICPC request. The first is the requirement for the Wisconsin ICPC office to send the completed referral to the receiving state ICPC office. If applicable, there's also timeframe requirements for the local agency in the receiving state to give provisional approval or denial to the placement resource. This is not always required. And you should again note that if there is a provisional approval, the final decision can subsequently be to deny, and the child must return to Wisconsin. Again, if applicable, the requirement for the local agency to give a home study report. Remember, these reports are not always provided, and they may not actually provide a decision on placement, and is just simply an update on how the home study is processing. And then finally, the last time frame to be aware of is the receiving state's final decision to be sent to Wisconsin ICPC. So for a Regulation 1, the Wisconsin ICPC office sends the referral within 5 business days of the receipt of the complete referral from the Wisconsin agency. And then the local agency in the receiving state has to respond with a provisional approval or denial within 5 business days of the completed request by the ICPC office. And then within 60 calendar days of that complete request, they have to provide a home study report. And then final approval or denial is due to the Wisconsin ICPC office within 180 calendar days of the receipt of the request. For Regulation 2, there's no specified time frame in regulations for sending the referral from Wisconsin to the receiving state. These requests are prioritized based on the receipt of other types that have required timeframes, and then a first submitted, first processed basis. There is no provisional approval for Regulation 2 requests, and the home study report is due within 60 calendar days, and the final approval or denial is due within 180 calendar days. For Regulation 4, there is no specified time frame for the Wisconsin ICPC office to send it to the receiving state ICPC office, but you should note that these requests are highly prioritized due to the time-sensitive nature of admission to a facility. There is no provisional approval, and there is no home study report for a Regulation 4. But final approval or denial is due from the receiving state to Wisconsin within 3 business days of the receipt of the request. And finally, for Regulation 7, it must be sent from the Wisconsin ICPC office to the receiving state within 2 business days of the complete request from the Wisconsin local agency. But remember here that it can only be forwarded to the receiving state if that court order we discussed is no more than 5 business days old. Provisional approval is allowed if it's requested by the Wisconsin agency, but it's not required. If the receiving state chooses to give provisional approval, it's due within 7 calendar days. There is no home study report for Regulation 7. And the final approval or denial is due within 20 business days of the receipt of the request from Wisconsin. But again, please note that different states have different requirements for doing home studies on their proposed resources. And so not all states are able to comply with Regulation 7 timeframes. So for example, if Minnesota requires licensure, they are not able to meet these timeframes for a Regulation 7 request. So now that we've reviewed some basic timeframes, let's move to the next step. If the placement was approved by the receiving state ICPC office, you as the sending agency make the final decision on whether or not to place the child with the approved resource. This approval for placement in the receiving state is valid for 6 months from the date the 100A approving the placement was signed. If after 6 months the placement was not made and you wish to still pursue placement, a new referral must be submitted and a new home study completed by the receiving state. So you should make that placement within 6 months. If the child is placed, you as the sending agency absolutely must submit a 100B to the Wisconsin ICPC office through eWisAquis within 3 business days of placement of the child. This form will notify the ICPC specialist of placement so that they can initiate supervision of the child in the receiving state. And this will also set in motion the process to end Wisconsin Medicaid so that the receiving state can certify the Medicaid for the child where they now reside. Once this is submitted, the receiving state must begin supervision of the child within 30 days of the placement notification. So once the child is placed, you as the sending agency will maintain jurisdiction of the child and continue with all requirements of the case. So this includes any case planning, any permanency planning, and all documentation requirements in eWisAquis, etc. And meanwhile, the receiving state local agency will continue supervision of the child and will submit quarterly supervision reports to the Wisconsin ICPC office. The Wisconsin ICPC office will upload these supervision reports into eWisAquis for your review. You, as the sending agency, are required to document caseworker contacts. But note that the monthly report analysis done by DCF to monitor caseworker contacts will consider that caseworker contacts for ICPC cases might not be entered monthly, as agencies only receive reports on a quarterly basis. Once you receive this quarterly report, you should document the monthly contacts in eWisAquis for each month. You may want to request a report about any visits during the final quarter of the federal fiscal year, so July, August, and September, no later than the last week of October, in order for you to document those in eWisAquis and be considered in the federal database. If your agency is not receiving documentation of these quarterly supervision reports from the receiving state, please just contact the ICPC specialist as soon as the problem is detected. They will work with the receiving state to address the issue. And finally, during the case, you should note that some states do not actually allow their local agency caseworkers to directly communicate with Wisconsin caseworkers for the purposes of case management, and actually require that all case communication be routed through the ICPC offices. This is per the state's local and state requirements, and we cannot override that policy. With that being said, Wisconsin allows you as caseworkers to communicate with the receiving state caseworkers for case management purposes, as long as all required documentation and communication relevant to the child's case, any of those big changes are sent to the Wisconsin ICPC office. Okay, so the sending agency's responsibility for the child will continue in that fashion until placement is legally terminated due to one of the following. If the child returns to their home state, returns to Wisconsin, has been legally adopted, has had guardianship transferred to the placement resource, has reached the age of majority, or in some other fashion discharged with the concurrence of the receiving state. And so once the receiving state gives concurrence for any of the discharge reasons above, and your agency is ready to close placement of that child, you must submit the 100B to close the placement with the Wisconsin ICPC office. And you should do this within 3 business days of the placement ending. This will allow the ICPC specialist to then close the ICPC record, which will then allow you to close your case in eWisAquis if that is. If the child's placement disrupts and the receiving state requests Wisconsin to bring the child back here, your agency must bring the child back within 5 business days of the request or within a time frame that you and all other parties agree on. Your agency is responsible for paying for and arranging for the transportation of the child back to Wisconsin. If there are any child abuse and neglect concerns, please note that the receiving state can place the child into another home until the child is able to return to Wisconsin. And so that brings us to a close on this training. There is a lot more information available if you need additional ICPC resources. You can first find more information by going to the DCF website, where there are additional ICPC webinars. One is about understanding ICPC in general, and the other is about what to do when you receive an assignment to an ICPC record and must respond with a home study or supervision. There is also a link to Ongoing Services Standards, which has an extensive ICPC policy. There's also a link to the EWISAQUIS Knowledge Web, which has ICPC user guides and webinars with EWISAQUIS walkthroughs. You can also find contact information for the ICPC specialist and ICPC assistant. And finally, a link to ICPC state pages, which has information about each state's ICPC requirements. And finally, there is an ICPC desk guide that will provide an overview of the ICPC process and some tips for sending and receiving. Contact your DCF Child Welfare Regional Coordinator for a copy of this desk guide. Thank you for listening to this training on submitting an ICPC referral. I hope that you now have a better understanding of the process when Wisconsin is a sending state and have the opportunity to check out more resources. Thank you.